Today's guest is Tarunima Prabhakar, the co founder of Tattle and one of the most thoughtful voices in the world of public interest technology. She has spent years working at the intersection of technology, misinformation, and civic impact. She holds strong opinions on the importance of data scraping for research and transparency. But despite working deeply in this space, her approach to our conversation was genuinely inquisitive. She doesn't just argue her side, she wrestles with the hard questions and complexities that challenge her position. I hope you'll find her thinking on the subject as refreshing and as thought provoking as I did.
Hello, hi Tarunima. Welcome to the podcast.
Hi.
So, for listeners, quick introduction to who is Tarunima
Okay.
and why do you care about this subject? Why do you care about data? Why do you care about scraping? I know you work on misinformation, but then broadly, why do you care about this domain?
Yeah. So I got into scraping, or the reason I had to think that scraping is, or I had to start thinking about scraping and talking about scraping, also writing about scraping, was in context of our work. So I have a background in computer science and policy, but also I'm very interested in public interest technologies and public interest research. And often we use scraping, and we would use scraping. And I think, for example, in 2016, in the context of some research, looked at Play Store reviews on fintech apps. And that was like the only way at the time to understand what was happening. 2017, 2018. That was the only way to understand what was happening with the fintech ecosystem, because there wasn't as much information. So I think as far back as I remember, writing scrapers, some of this for data collection was always part of my work. And then in the context of Tattle, so Tattle is a civic tech organization. We started it in 2019. And one of the reasons why we started it was because there was so much opacity around what was happening on WhatsApp. We wanted a way to connect what was circulating on the platforms with information, like fact checkers doing their work. And one of the ways of getting to that opacity, or getting past that opacity, was to build data sets. And we saw what, scraping, at least for Twitter, Reddit, etc., has been happening for many, many years. And we felt like there had to be a way of revisiting sort of those same questions for platforms that were being more commonly used in India. And we definitely had to think a lot about, when you're looking at, say, closed messaging apps, what of that is public, what of that is private, right? When is it that you can assume that this content is like public interest content, or not, if not public interest, but this is like broadcast like content, and therefore you should be able to collect data sets. So it's something that we've thought about a fair bit. At some point, we got a cease and desist notice from a platform in India, which was a social media platform. And I think that was the first time it kind of like hit us pretty strongly. And of course, we, at the time, I think had a very like visceral, strong reaction to how can you use the IT Act to say that this is fraud, when it's very clear that you're not accessing someone's servers, right?
Yeah.
So I think I used to like to think of us as like the small folks trying to like shed some light into a very big, dark, opaque beast. I understand why that's not how everyone will look at it, right? At the time, I think we also realized that beyond, say, a small group of, I think, computer scientists, maybe public interest researchers, the general public doesn't quite get scraping. And so if, let's say, this was to go into media, or if it was to go to a court in India, we're not quite sure how the court would look at it as well. Because when you start describing scraping in lay terms, I think people land up thinking of it as like it can often like appear to be theft, right? So I think it's like something that has that is very part and parcel of, in some ways, like computer science education. It's something a lot of university students do, is like write scrapers for different websites and do fun projects. It's almost like something that becomes normalized through a disciplinary practice, but when you start like taking it out of that domain, it starts appearing quite weird. And then I think that all of this kind of came a full circle and became very much like public domain with the rise of large language models and ChatGPT. And right now, I think scraping has become more visible to the public than it was, say, 4 or 5 years back. So I mean, I feel like I've tried to have this conversation around scraping with a lot of different people in a lot of different domains to see, okay, how are people thinking about this issue. When we said that we would do this podcast, I don't think scraping was the first thing on my mind.
No, actually, it was trolley problems.
Yes, it was trolley problems. Yeah. But yeah, I think as I was talking about it, I think it's one of those things that we still feel quite strongly about in terms of. I am quite concerned about what will happen with a lot of this regulation that will emerge because of concerns around data being used for Gen AI and what that means for researcher access. Because a lot of it, like Reddit blocked its API, Twitter blocked its API, right? Like none of this is available now for researchers to do the kind of work that they were doing. And so I do worry a fair bit about, okay, like what is the backlash? So here I am taking the extreme position of saying that scraping on the public web is all right, or like we should have the right to scrape on the public web, right? So I think that's the position we're going to start with. And
amazing, perfect.
Yes, and then I and through this I think go into all the like complexities and nuances that I think sometimes we also have to face in our work.
Yeah. Usually most guests I have, when I attempt to like get to the heart of why do you believe what you believe in, it always boils down to that visceral reaction. Like they say, akin to, I feel it in my bones. It is so true, not because it emanates from a purely intellectual place, but because viscerally, it just emerges as like an axiomatic truth that I just hold as something that is a North Star and a compass, which is awesome. So to get listeners to understand your position a little bit better, in more words than just like a short description. When you and I went back and forth, you used a phrase like approximately you're a data scraping maximalist, right? In that as much as one can. So I want to just allow you to define the boundary conditions here. So words like publicly available is a boundary condition. What are the other boundary conditions that you feel are relevant?
Yeah, I think it might actually emerge from the questions, that you ask. But I think the big boundary condition is public, actually, because when I say data scraping maximalist, we also, for example, work with communities and also like think about what is co-ownership of data sets within communities, who has right to then use some of this data set, what is the reciprocity between the people who are using the data, etc., right? So I think I think like I will actually for now just keep the boundary at public, right? And then I think that's where we should start. And so within that boundary of public, I am saying maximalism, and and I think what I expect we might hit against is that there are ways that in part like the distinction between like it's a continuum between private and public, right? And I think that's where we will actually hit with a lot of tensions of what are those boundary conditions on which scraping may or may not be allowed.
I agree. Yeah. Before we dive into that, you used a word in the introduction where you said that your behavior could have been construed as theft. And I think the interesting thing about a word like theft, which by the way, I think in like intellectual discourse comes up all the time. Right? You have like folks on the left saying property is theft. You have folks on the right saying taxation is theft. And then you have folks in your domain saying like scraping the web is theft. Theft is like a word
that's not people in my domain. People like I think
folks who stand antithetical to the work that you all do, saying that this is theft. This is theft. And I think it's like a really interesting word, but it's predicated on actually what the word property means. Because you cannot steal what is not what we not agree is agree at least mutually is defined as property. So we're both not lawyers, and we clearly both have not practiced arguing this in a court of law or doing it formally. But just from its application to digital rights, what is property?
So I think this is where because I also come from like the open source domain, right? It's actually in that domain that I've actually thought a fair bit of like what is property, and I think the typical way of definition of property is the right to exclude, right? So intellectual property is that I have the right to exclude from someone else having access to the same thing. That's one way to define property, right? And then I think the open source movement's way of defining property, or not necessarily defining property, but this is actually how they look at property is the right to distribute. So who has the right to distribute my work, right? So when you say, for example, that it is like share alike. So that means that if you have forked my code, you have the right to you have the right to distribute versions of it, right? As long as I am attributed, right? Like that's in some ways what property means in the case of open source code. And again, both kind of coexist, and one could, I think, in some ways with data, I'm just thinking like what is practically more doable, because with data, which is something that's like non-rivalrous and in materially non-excludable, right? Like just because I have data doesn't mean that you can't use the same data, right? The right to exclude definition of property actually is like harder to materially hold on to.
And if you contrast this to physical property, like I own a guitar. If I own it, you cannot own it because I physically hold on to the guitar and you can't physically hold on to it.
Exactly.
And so the right to exclude, you're saying, needs to be much softer in digital property, simply because by definition it is not rivalrous.
And I think what I'm also saying is that the material nature of data pushes that like definition of property as the right to exclude.
Right. So the way I have understood the right to ownership, because this emanates from like Lockean thinking, right? That's typically where you end up justifying why I can own something. Is you start off with the right to self-ownership, which is, as far as I can understand, and I did an episode with Amit on this where he tried to defend liberalism. As far as I can understand, feels like an a priori leap, where I'm just making the leap into this belief that I own myself, you own yourself, we all own. No one can own another person. We can't have slaves, we can't own our children, we all just own ourselves. You may have temporary periods of guardianship, like a child may be under the guardianship of a parent, but by and large that doesn't change. And as a consequence, that right is a property right. I'm owning myself. I own my labor. And here's another leap, I own the fruits of my labor. So if I were to walk up to like the shore of a river and turn the sand into a pot, then clearly I have used ingenuity and my labor and my time to craft this publicly available resource, which is the sand on the beach, into a pot. This is now quote unquote my pot. I own it. If you take it from me, it is now theft. I can enlist the state by granting it a monopoly on violence to step in and defend me using the coercive power of the police force to prevent you from taking my pot. It feels like these are the leaps that are like a TLDR here, ELI 5, these are the leaps that are made to get to why we own something, right? Now I'm trying to translate this to digital property, because frequently when I attempt to make the translation, the positioner here is, look, if you cannot own digital property, then you cannot monetize it, which removes fundamentally the incentive to create digital property. So for example, if you were to write a book, sorry, I shouldn't say digital property, I should say intellectual property. If you were to write a book and you did not have a way to copyright that book, that is, I was to say, you own the physical copy of your book. So you took a pen and you wrote in a literal on pages, and that book is yours, good for you. But if I were to make a copy of the copy of the book is mine, right? Because what you own is the physical property. Your labor has been poured into a physical asset. That physical asset is yours. The intellectual asset is not real. It only exists like metaphysically. It doesn't exist physically. And so is not something that we respect using this Lockean conception of rights, right? And property. Then the usual pushback I get is, no, but then we remove the incentive to write books, because why would people write great books if they can't monetize and publish and own distribution? If it gets copied immediately, then all the hard work goes for nothing, right? Okay, now I want to zoom back out here. In your mind, is this distinction real? Is the distinction between physical property and intellectual property a real distinction? Is intellectual property even really property? And should it be protected like we protect physical property? And here, the rivalrous nature of the property has not come into question. Like in this first principles thinking, we've never questioned whether it's rivalrous or not.
Yeah, I actually, again, not a lawyer, so I don't know the history of intellectual property and where it emerges. But I think when you say that there's something that is physical property and can be handed down, say, like generation to generation as a rivalrous good, I think the intellectual property argument, as you're also saying, is an incentives argument, right? It's not a material nature argument, right? And it's and that has been my reading of almost all intellectual property discourse, is that we need to provide incentives, and therefore your licenses expire, right? Like it'll expire after 20 years, it'll expire. But that is not something you extend to physical property. You don't say that, it's just because I have a guitar today, like 30 years later, it'll become the property of the state.
Yeah.
So I think that distinction already exists. right? And I think, so I don't think the Lockean idea is being extended to intellectual property in any case.
Got it.
Yeah.
Then the word theft comes into question.
Yeah.
Like that's the bit that I'm pushing back on.
Yeah.
So, okay, now maybe there are two ways to do this. The first is to question the license.
Yeah.
So, do you feel like it is reasonable that we do grant licenses to folks who created intellectual property?
Yeah.
As a way to incentivize them? Because I could make a first principles argument and say, no, we've never justified why we should be giving out these licenses. Incentives are not the job of the state. The state exists to protect rights. The state does not exist to incentivize you to write a great book or to make a great piece of music. So why should even the license be something that the state protects?
So I think first, when you say that the state only exists to
protect
rights, I don't necessarily agree with that, right? Like, I mean, that's a deeper argument I don't want to get into right now, right? So so let's just start from the premise that there are some incentives, or you need incentives to produce intellectual labor, right? Now, are we disagreeing on whether that statement is true? Like, should there be incentives to protect to generate? Are you disagreeing on that?
I have to. It's in the premise of the podcast.
No, I understand. Choice. So I'm trying to understand where the source of the yeah. So you're saying that should there be any incentives to produce intellectual property?
Should the state erect those incentives? So the way I would construct this is, I would say that if you think about the journey of an entrepreneur, and I mean, again, I'm making this in opposition to the case that you're making, right? So that it's just, an entrepreneur would invariably have to do many things to get their quote-unquote business off the ground. They have to come up with a unique product, then they'd have to figure out marketing, distribution, you know, their customers, price point. 100 things have to fall into place. One of those things is, how do I make sure that the thing I have created does not fall in a one-to-one ratio into the hands of my competition, right? And we can copy lots of things in today's world. So if you launch a marketing campaign, I can copy your marketing campaign. There's no real way to trademark or copyright or patent a marketing campaign. Right? So already for lots of things, we say, no, this is a competitive landscape. We rest upon the entrepreneur, the onus, to figure out how to be protectionist about their own business. Right? Why not extend this to the intellectual property itself? That's the question.
So I guess, like, before we get into data, let's just think about books, right? So can we expect an author to be protectionist about their own work, right? Without, say, having some protections guaranteed by the state in terms of a license or the enforceability of the license. So I'm just thinking about this, right? That if I had the ability to reach out to 100 people, so I wrote a book and I have the ability to reach out to 500 people without an intermediary of a distributor, and then I get, like, immediate social capital, and therefore, like, I am being invited to give talks around it, and I, like, the returns are directly accrued to me, then not, right? But if I do have to rely on intermediaries and like the distribution is diffused, etc., the attribution matters, right? So if I produce a book and then someone else, you know, I'm thinking about the pre-internet era, but say someone else in another country got hold of that book and then eventually published and said, I mean, this happens in India. I guess it's happened with Bollywood movies all the time, right? And we've not particularly cared about, I mean, Hollywood has not particularly cared about Bollywood movies and sued Bollywood film directors for, I guess, like, intellectual property infringement. But I will say, I mean, but I guess in cases when it has happened in the opposite direction, where, say, like, a Japanese director's movie has been adapted by a Hollywood like director, it's always felt like, oh, like, this is weird, because I think we do have, like, some instinctive sense of, like, the power disparity and saying, like, right, but not to the point where you're saying that, acha, this is illegal, or this is, you know, where, like, say, the WTO needs to step into this and protect the interests of the Japanese directors, right? That's not happened. I think, like, there is, I again, maybe, like, an understanding that in both cases, both sides have made some money from the enterprise, right? And someone, like, you're not as upset, like, it's almost like the markets are separate, and so, like, the Japanese film audience is probably not watching the or, like, the Hollywood film audience is not watching the Japanese films, and therefore, you know, if the idea has been adapted, we are not in some ways competing. But I think with book ownership, if it is literally the direct copy and there is someone else who just says, I have written this book, it is literally undercutting someone else's market, or, like, someone else's, whether it's economic capital or social capital, it is undercutting that, right? And therefore, I'm not sure in practice there is a way for an individual solo endeavor or like to protect its interests when your like consumption and your sort of market is so diffuse and not something that you have like a direct reach to, right? And I think in absence of that, the license ensures that some of this work continues to happen.
Like it's a pragmatic way to get around this whole problem.
I think so, yeah.
Because the one of the things I can think of as a response to this is just that private markets will emerge to solve this problem. If the state does not guarantee licenses, distributors today already fairly important in the world of books or movies.
Yeah.
Somebody plays the role of distribution. They will also figure out over time, over a 10-20 year period, become significantly better at protecting the material itself such that it doesn't get copied. That's one way to look at it. And even in today's world with the license, etc., piracy exists. So it's not as if the licenses have solved for too much. In that they've not made it impossible.
Sure.
Only illegal, but almost impractical to even clamp down on the piracy problem itself.
But I think the piracy problem is a slightly different problem, right? Like I think what I'm talking about with the intellectual property bit is that if you have a person who's written a book and then someone else copies it and says, I have written this book, right? That's the first case that I'm talking about. And I'm saying that in some ways, so when you say that the private markets will emerge to solve this problem, I think licensing is in part a private market, right? It benefits the distributors more than it benefits anybody else, right? And it's almost like you have a bunch of different entities that are competing, and then you have gone to the state as the arbiter of saying like, I need you to enforce a standard that we think is a private market solution in some ways, right? So I actually do think the licensing is a private market solution, in some ways a very flawed solution. And then I think the separate aspect of it, which is like piracy, which is that I think it hits on
to the original owner.
Yeah, I think it hits on the economic capital. It does not hit on the social capital, right?
That's really interesting.
Yeah. And should we be worried about the implications, like, like no one's making money because this copy is available everywhere? Again, I think the Netflix piracy example is a great way to say that, yes, when like there is a way that the market makes it more feasible for you to just pay some money to the creator, as opposed to, because there's a cost to piracy as well, right? Like
Correct.
It's yeah.
And I mean, first of all, I could like sort of ask, what is the problem with the loss in social capital?
Yeah.
But beyond that, it feels like this is not a distinct problem to the arts.
Yeah.
It for example, who discovered CRISPR? The technology by which I show. And the answer actually is that lots of folks did it in parallel.
Yeah.
But whoever got to a publication first, sort of got recognition for it first.
Sure.
So I'm sure that even if you were to write a book and you were to already begin publishing, there's evidence that you've written the book first. I were to simply make a copy of it and start selling it in different countries under my own name.
Yeah.
It's only a matter of time before which I am outed as somebody who has lied about the entire process. And within a span of a few years, will become less and less likely that people like me even act or exist, because now middlemen will appear or distributors will appear who will figure out ways to make sure that we don't attribute incorrectly and sell in the wrong name. We'll get better at this, perhaps, right? So first of all, is social capital loss a big problem? And then still, why do we need a license to solve this?
I mean, I think from lived experience, social capital losses doesn't get resolved as quickly as you're describing it, right? Like in the sense that you have so many stories of, like, this is, of course, in the women in science, women in STEM, so clearly documented that a lot of women scientists were not attributed, right? And I think we've had to go out of our way to like go find those histories and be like, okay, who were these people who were working in these labs, right? Who were not attributed. So I think actually, like, no, social capital, like, often attribution just is lost to history. So I don't think like market resolves that. So you do often need that explicit effort. I mean, I'm saying this is like the women in STEM because that's a literature that's coming to my mind right at first, but you also observe this in workplaces all the time, right? So I actually do think the social capital
bit is important
attribution
enough that a license is the way to
important. As that a license is important. Now I think we can get into the specifics of the license of whether, at least in the context of books, it should be 5 years or 20 years or 50 years, right? And that's actually where a lot of the intellectual property discussion has been, right? And also, like, when you are talking about the license, is it being when it is held for 20 years or it's held beyond the lifetime of the author, it's obviously not to the benefit of the author, right? It's to the benefit of an estate, a publisher, etc. And so I think those conversations, like the specifics of it, are worth having. But I would not say that we should by default have all intellectual work just be published as public consumption without attribution. No. And I think even in the most permissive license in the open source spaces, you don't have that, right? Like, you will always say attribution is key. I don't think anyone is ever doubting that premise, that the creator of the work is important. Yeah.
Got it. Okay, perfect. And as a final question on this arc, on the economic front, are you okay with piracy?
Yes. I mean, okay. I mean, again, my visceral reaction to this is because I grew up, I used to say, like, I'm like a veteran pirate. I used to be on, like, torrents all the time when I was growing up. And I landed up reading a lot of books and watching a lot of things as a consequence of it, right? So, I had this very strong reaction of piracy, yes. But now where I am, and I think this is a journey that a lot of people in India have gone through, right? Like, a lot of us grew up watching pirated content, etc. But we are at a point where we will pay for it, right? Like, so I'm also one of those people who's like read a book, liked it a lot, and then gone and bought the original because I'm like, no, I want to actually.
But if you didn't like the book,
if I didn't like the book, I have
then
not.
You're like, fuck this out. I'm not paying them.
Yeah, exactly. I've also but I think with a lot of knowledge in so I also felt like when I reflect on the kind of things I was watching on torrents or reading on torrents, it wasn't like the cutting edge, like the latest book, right? It was often classics, which I didn't have access to wherever I was. And so for me, that the access, like, it feels so important to me in my life, in terms of like my growth and like my reading, that I'm like, yes, of course, like, as an equity argument, people should be able to access a lot of this content, right? Whether pirated content, so say like a film that's just come out in the theaters, and you'll always have that poster saying, that note saying piracy is a punishable offense, that sort of a thing. Am I in favor of that? Like, again, there's like, I can tell you what my personal intuitions for this are. And then the second question is, like, should there be the state intervening on behalf of my personal intuitions, right? So my personal intuitions for this is, I think the public case for it, or like for something that's been newly released, has not been made, right? So whereas a lot of the literature that is, say, like 10 years or older, I think the public case has been made. And I feel the same way for scientific publications, right? Like, it's been funded by the state. Why are we then paywalling all of this content? So I feel quite strongly about, for example, having access to scientific peer-reviewed publications should not be behind a paywall, right? And they should be publicly accessible. And if people are pirating and reading papers, I'm like, great, do that. Can I get into jail for saying stuff like this on a podcast? Do you know this?
I have absolutely no idea.
Okay,
but if you and I go to jail, Rohit goes to jail.
I don't think Rohit.
Everyone here at the studio goes to jail. So there's a there's a crew going with us.
We'll figure this out. But yes, so I think to continue on that.
No, but sorry. But the point that you were making on the scientific publication front, the Indian state seems to agree, because now they've reached a place where they're lobbying entire publications into like a collective payout and saying researchers have this as a free of cost product. At which point, why not just make copyright laws more lax?
Which I think India anyways has, right? I think this Indian government's like state response is a way to contrast, or to basically at a global scale negotiate or engage with the framework, or the intellectual property framework that exists primarily from like the US and Europe, right? I think the Indian copyright rules have been, people in India would say, been way too lax. So I think we don't have to worry about copyright laws in India per se.
Within the Indian context, but in this explicit case, because the Indian government is spending taxpayer capital on purchasing licenses to make journalistic publications, scientific publications available to researchers at universities. That is a lot of steps.
Yes.
More complex than just saying we don't respect copyright.
But I actually think this is an economic calculation, right? Because is it easier to do this, or is it easier to fight the publishers at WTO? And right, I actually think this is just a very calculated. Basically, the Indian state could say we will not do anything about it. India would continue to people in India, researchers in India would continue to go to Anna's archive, LibGen, whatever. And then you would have individual cases happening in different parts of the country, publishers suing. And I think this is just a more efficient way of resolving the dispute, right? Whether the Indian state should have taken the moral high ground of saying like, oh, we are, pro copyright, or sorry, not pro copyright, we are pro breaching copyright, and we think everyone in India should do it. Sure, they could do it, but I just think it's easier to resolve it this way. I mean, taking moral high ground often, has very clear economic costs. I think this is just,
speaking of the moral high ground.
Yes.
So to make a case against piracy,
I
have a dear friend who is explicitly clear that anything piracy is theft.
Okay.
Torrenting something is explicitly in the domain of theft.
Okay.
Irrespective of age, whatever. No caveats.
Yeah.
And I feel invariably, any defense of intellectual property ties back to an analogy of physical property, because we've just conceptualized property as physical property for the longest time.
Yeah.
That this new domain has to have in some way like a mapping to physical property.
Yeah.
So he says something like, this is akin to you having, apple trees.
Yeah.
And somebody coming and plucking just a single apple from the tree.
Yeah.
Now, that is an economic loss. You
Yeah.
do have other apples to sell. You do still have the original tree.
Yeah.
The tree will bear you more apples.
Yeah.
None of that is going away.
Yeah.
But losing that single apple still meant that apple could have been put in a marketplace and sold at a financial upside to you as the producer or the owner of the apple.
Yeah.
I'm trying to get to that because, all this is a long-winded way of figuring out when are we stealing something versus when are we not. Right? Is scraping the public web stealing or not?
Yeah.
And is this akin to plucking an apple from a tree?
Is scraping the public web akin to...
No, let's do torrents first, right? Like is torrenting something or pirating somebody's book? LibGen.
Yeah. See, again, I think when you look at the open source commons, that world, right? I think they would dispute the starting point of property as something that is mine, or like this idea that the only way for markets or for prosperity is to define a property that others cannot access, and therefore I have the right to sell it to someone for monetary, right? Like, I think that basic premise is also in dispute, because then this idea of commons is that it's not as if it's commons is access for everybody in that community. There are forms of governance, and there are norms of reciprocity. So I would say that is one. Okay, but let's assume that we are still operating in the world where we are saying that the definition of property rights is important for economic development, right? Now you're saying that your friend's argument is that all forms of piracy is theft, and all forms of whether it is a 80-year-old book, whether it's a 40-year-old book, if you've gotten it off torrents, it is theft. And
unless it's like the Bible or something, like unless we don't have a clear owner for this product.
Sure.
The argument that would follow would be the creator of this intellectual property has not consented, and we'll come to consent, but let's say that they have explicitly said, I do not want this to be pirated. I do not want anyone to have free access, right? They have signed an agreement with the distributor, distributors, publishers, whatever. None of them have consented. Then you have a buyer who's purchasing this product, the book, and then making whatever a scan copy and putting it on the internet. So it's a violation of consent on so many levels that it must be theft, right? Like intuitively that's where this person would land.
Yeah. So again, I think if I had to think back, I'm trying to be consistent with what I've said earlier. If, let's say, your license is defined as 5 years, if in those 5 years you are copying something, and we're saying that, okay, 5 years is roughly the time that ideas, or say like 5 to 10 years is where ideas stay relevant, therefore someone should be remunerated for the ideas and the relevance that they have. And after that, it becomes either like it's so diffuse that it's become like a popular idea, everyone kind of knows about it. And I think like, yes, so in that 5 to 10 year period, I would say that yes, that is theft, right? Or like there should be some more than, okay, like theft, like there should be some penalization for having done it.
Copyright violation.
There's a copyright violation, and there should be some penalizing for having done it. Now, beyond that, right, which is in part, so I think, for example, some of the things that I was reading or watching on torrents, right, just practically, because a lot of the more new stuff would just be bad quality, right? So you would land up going for like some of the more classical or like whether it's movies, music, or even books, right? I mean, to me, it's still copyright violation. I should have possibly gone and bought a book, which I couldn't have done at that time. And I think in terms of consequences, I feel like, no, I like learned something new. I don't think this person would have...
They have not lost any revenue because you would never have bought the product in the first place.
In the first place, that's also the case. I would not have... And I would say that, after like 10, 15 years, you've probably made all the money. You're like moved on to other projects. So again, I think what is probably frustrating about everything that I'm saying is it's so like case specific and it's so like contextual, and you're like, but what's the broader philosophy? I think what I'm saying is that if I had to argue it for policy, I would argue in terms of the numbers of the years of the license, right? Because as an individual, I'm not able to argue at the policy level on every aspect. I definitely am not arguing on the copyright aspect and pushing for, like, say, limitation of the number of years of a copyright license. I am breaking the law often by pirating content, and I am okay with it, right? Because it aligns with what I believe policy should be. And as a person, I am holding on to, like, saying that, okay, if there's some new content, or if there is a documentary that, etc., like, that I'm not going to go watch it. I'm not going to watch it online. And I think, like, when the market solutions have existed, all of us have actually not done the transaction costs of accessing ideas. When it has come down, we have paid that transaction cost. When it has felt too prohibitive, we have gone and pirated. Right?
You are such a great guest to have on a podcast like this, because I feel like half the listeners will be just like, what the hell is she saying? This is totally fucking crazy. And the other half will just be like rooting for you nonstop, because they're like, of course, this makes complete sense. So fairly divisive. And I think it's divisive right along the middle.
The question is which side are you on, right? Like,
privately or in the context of the podcast?
In context of the podcast. You're like,
exactly opposite wherever you are. If you happen to change your stance midway, I'm changing my stance midway.
Got it. Yeah.
Okay. As you were talking, actually, you were talking about, like the time for an idea to diffuse and sort of for them to make money in the process, and then eventually it stops making sense to be so protectionist about this.
Yeah.
I'm thinking about like Harry Potter.
Yeah.
So J.K. Rowling creates this universe.
Yeah.
And it's fantastical in so many ways.
Yeah.
She clearly takes a lot of effort on her part.
Yeah.
And then publishes all the books.
Yeah.
But we don't know yet, for example, if she will publish a follow-on movie.
Yeah.
Right? That we don't know, but it's entirely possible, and now it has so happened. We don't know if there will be a new book that gets released, 20 years later, that is just like the life of Harry Potter when he's in his 80s or whatever, right?
Yeah.
Any of these things are possible. And I feel like the theft, the aspect of this that could possibly be construed as theft, is stealing her ability to meaningfully to embark on that economic enterprise.
Yeah.
And as an extension, it's not just the intellectual property of the book that she owns, but the characters themselves.
Sure.
She owns Dumbledore.
Sure.
And she owns Harry Potter and Hermione and all of those characters.
Yeah.
So if I would write like a new Harry Potter sequence,
like a fan fiction kind of thing of Harry Potter,
and I were to commercialize it, that is, I was to go out and actually sell copies of this book, and put it in the universe of Harry Potter. Would she be justified in coming after me with the arm of the state and saying, sue this person, because like this is diluting, the original Harry Potter. I've written and built this entire enterprise, and this person's diluting it by I haven't licensed it to them.
I mean, again, in the world as it exists, she has full right to do that, right? If I was in her place, I would not do it, right? That's what I would say. That if I was in her place, I would say that if any of this fan fiction work is evolving, it's still in some ways a homage to the work I have produced, and therefore, like,
even if it's commercial, because the key bit is
even
that
if it is commercial, it is something that is a homage to what I have produced, and if that person goes on to make more money, that's something I would be okay with. I would say, like, I don't want to be envious of the fact that this person has, it's fine. Like, you put out, as a creator, put out a seed to something great. That seed always exists as long as, like, you are attributed for it, which you will be, because those characters, etc., are quite well known. Now, if someone has gone and made something else, like, sure.
And if someone were to make a movie without your consent, following the plotline of the book.
Following the plotline of the book, will I... So if, let's say, someone adapted the first Harry Potter and did not give rights to the author, right? So I think in the current regime as it exists right now, if it was like an identical copy, then I think you could you could claim some,
100%. I'm sure you can sue,
Yeah, but I think like say Pride and Prejudice is the one that has been adapted in so many versions, right? Like sure, no longer alive, but I mean, I'm saying Jane Austen's no longer alive, but let's say this had happened in her lifetime, and let's say you had 4 adaptations of Pride and Prejudice, and you had what was the Bollywood film that came out of it, right?
Yes, I would know,
yeah. Oh, you wouldn't know. Sorry. Okay. I think it's like harder to make the case, right? Because like the broad contours of that story, like sure would have probably you can find like you can make 5 adaptations where it roughly follows the same like 2 characters and the families, etc. Again, if I was in Jane Austen's place, oh god, I wish I was, but like no, I don't think I would do that, right? I think I would just I would let that idea go, because again, I think the genius in a lot of intellectual work, it's not scientific work in which you've like discovered something, right? I think a lot of the genius is in the writing. It's not as if it's just like this character. It's about the engagement. It's all of it. And so if someone's doing an adaptation of it, in some ways, I think it's distinct enough that I don't think it's worth going after it as like this is a copy or imitation of my work.
Got it.
Yeah.
Okay. So I feel like in some way we've pointed at what we think property is and what theft is and isn't, right, broadly. Now on the other side, I want to talk about what does it mean to create something.
Yeah.
Or can we squarely say that this person is the creator?
Yeah.
And we have multiple instances, right? So you have things that are created across generations. So somebody starts off and somebody else finishes. You have things that are created collectively.
Yeah.
Then you have things that are created by a single individual.
Yeah.
But that also would be, I mean, if I had to be philosophical about it, I could say that no person creates in a silo.
Yeah.
You still borrow on ideas that others have. To what extent should I truly say that this is the idea that inspired me to do this specific or go on this specific journey and write this or create this. And then depending on creation, does the ownership change? So like an example would be if tribal groups for long parts of human history have owned collective knowledge about medicine.
Yeah.
Just what works, if you fall sick, what you do, right? Yeah. This is now intellectual property.
Yeah.
It's extremely valuable because it means that we increase odds of survival, all of that.
Yeah.
Now in the modern democracy, that is also, these are capitalist states.
Yeah.
It's possible to monetize this.
Yeah.
However, tribal groups, as an example, do not want to participate in this way of the world operating. They don't want to set up a private limited company and distribution and marketing and bottle it up and go sell it.
Yeah.
But it could be the opposite. That's big pharma could come into a small group, learn what they know, and then go out and sell.
Yeah.
In this case, do you feel like this small group has the ability to go after them and say, look, this is wrong. I mean, this is theft. And this is and also question me, who owned it?
Yeah.
Who did I steal from specifically? And the answer would be something like the entire community. Yeah.
I think more than this argument of like this is theft, right? It is that the bigger challenge is that when the big pharma has picked up this idea and has monetized it and then made it harder or has basically then enforces that copyright against the tribal group itself. Like this happens in the open hardware community, right? Like so for example, one of the big challenges with open hardware is that you would produce an open hardware design. Someone in the US opens the design. Someone in China makes a gadget out of it, patents it in China, and then like there is like a conflict, like license conflict. This happens in open hardware quite a bit.
Yeah.
Also with hardware, it's harder to like tie attribution as it is with software, right? So then the challenge is actually not so much that this entity sort of course there's this thing that the entity has copied it, but there's also like, okay, now this entity is going to come back at you and not let you do what you wanted to do, right? And of course in that is a very frustrating dynamic, right? Because like in some ways then the two cannot coexist. And so I think more than it's almost like a defensive strategy, or like if you're trying to say like the two should coexist, then this group does have the right to, like, the only way it enforces that its way of being can continue is by saying like, okay, therefore you do not have access to what we, or like the specialized form of knowledge. Because when you do use that specialized form of knowledge, you will come back at us and then not let us do what we want to do, right? So yeah, I think that kind of does answer your question. Yeah.
But there are 2 points of failure here. The first point of failure is, should the pharmaceutical company in this example be allowed to take this communally owned knowledge and convert it into a commercial product? Then the second point of failure is, should they then be allowed to copyright that? Because clearly in this process, they've also innovated. They've taken something that is like an Ayurvedic process in a particular location and figured out how to, they've tested it. This has now been peer reviewed. They have published. They have confirmed that it is actually safe. They figured out how to manufacture, distribute. So there have been multiple innovative layers on top of that this company has specifically accomplished. And then the second point of failure is, can they now say that I have innovated so much on top of this pre-existing knowledge that I am copyrighting this, that no one can copy this, not even the original people from whom I took the original seed of the idea. And seeds of ideas come from all over the place. So,
So, okay, so your question is, should this pharmaceutical company even be allowed to
copy in the first place?
When the seed of the idea has emerged from? So I think one thing so what practically happens often is that you don't know that the seed of idea has come from another source, right? And so let's say there are 2 ways of knowledge. One is empiricism, which is the experimentation way of like science, which is how in theory pharmaceutical companies, that's what they're adhering to. And then there is, say, another way of knowledge which is not entirely rooted in empiricism, and but it is effective by like subjective experience, right? Now can this entity, so if this entity has basically picked up that seed of knowledge, not acknowledge it, and this often has happened, like, I mean, this is not even has happened, and then has just basically empirically said that, okay, this is worthwhile. Should they be allowed to copyright it? Again, I think
that first layer actually, is theft allowed? I mean, I won't use it. Can I can I copy on the first level?
I think you can absolutely be inspired by ideas. You can get ideas from practices of other groups, right? And you can innovate on it, etc. Now, again, the challenge with pharmaceutical IP is like the fact that if, let's say, you have discovered this tree, a guava tree is good for, I don't know,
digestion.
Sorry?
Digestion.
Yeah, or a guava. I mean, I actually remember this being like someone saying the guava leaves were good or neem leaves are good for like your teeth, right? Like now okay, so this is like wisdom, etc. But if the consequence of the copywriting is therefore that only that pharma company goes and gets to harvest all neem trees in a particular country, then this country doesn't have access, right? It's all the downstream consequences that actually make it very frustrating. I think you can,
Yeah, this is a hard one.
No, it's not hard. I know where my intuition lies. I know what my intuition is. I think it's more like I'm trying to figure out.
Okay, then tell me.
My intuition is like your. My
Fuck this company.
Is...
Fuck Big Pharma. Yeah.
My intuition is yes. In this case, no, because that knowledge was public knowledge, or like was common knowledge for a while, and then by copywriting it, you are making it difficult for something that was common knowledge to exist as common knowledge, right? I'm not saying that pharma should not be patenting paracetamol or CRISPR, whatever, right? Like I see that there is a lot of innovation there, but if there was a way of healing, or if there was a existing method that then becomes inaccessible because someone else has done a copyright to it, I think that is a problem. So therefore, in that case, I would say it should not exist, right? Now, if let's say Big Pharma like took that neem idea and built a pill around it, and then it like patented the pill, I would say sure, as long as it doesn't it sort of impede the ability of the people who actually had that knowledge to continue doing what they were doing. So yeah, that's my that's my instinct answer.
I feel like you are right that this exists on a continuum and a spectrum.
Yeah.
And our intuition will shift just a little bit for every grade point. It becomes darker or lighter.
Yeah.
An example would be, let's say that within this collective, this tribe, let's say, a child is born and she's entrepreneurial and decides that or receives like an education at a formal school, understands what a private limited company is, and were to so then set up a corporation that leveraged the fact that her community knows some things about healing that other communities don't, and were to then build a business, I suspect that your angst at this person would be significantly lower than a foreign pharmaceutical company.
Only if this person doing this business did not impede the ability of others in the community to do what it was doing, right? Or so as long as it did not exclude the ability for someone else to continue whatever was their way of life, right? And so I think to the extent if that happened, I would be as opposed to this person doing it.
Yeah. Then it feels like you're consistent on the fact that you don't want copyright anywhere in this journey, which is when Big Pharma steps in and says, I'm going to copy what you all are doing with your neem leaves and guava trees, you're saying, cool, let them copy. And then when Big Pharma sets up a business model that can distribute this far and wide, and an innovative product, you're saying even there, they're not able to copyright anything. No one anywhere in this journey should be able to copyright anything.
I think what I'm saying is that the innovation, when you say that they have innovated sufficiently that they can copyright, I'm saying that if that innovation is sufficient in that it is so distinct that it does not intervene or does not impede the original way of life, it is fine, right? If they want to copyright it, sure, they should copyright it. I'm not saying that there should be no copyright along the process. I'm saying that the copyright has to, it is hinging on like what is that innovation enough, right? And often I think like Big Pharma taking a guava leaf, neem leaf, etc. and is not copyright enough, or is not innovation enough. So I don't think I'm saying that there's no copyright. That's not what I'm saying.
The only way to answer this question is to have a lawyer stand up in front of a judge of some sort, somebody who's like an intellectual property lawyer, and then make an argument for this. And it could be something as simple as we figured out how to improve the shelf life from this medicine that typically lasted 3 days to one that lasts 3 years. Beyond which there is no other innovative step. And and would you then say that, this is actually innovative enough? You moved shelf life by 3 years.
I mean, again, I think it depends on the specifics of the case, right? And I think that's kind of all what intellectual property like litigation is about. So I don't know if it is even that productive at this point to like craft the hypothetical example.
Fair enough. Right? I think I'm getting where you're going at. Okay, and on the question of what you do about, so one of the examples that you and I were speaking about, and you can please elaborate, is let's say you have like a book that has been collectively held by a community. So it's either sacred to them or it's part of their folklore, mythology, whatever. This is just a fictional tale. The knowledge of what lies within that book and the exact story is possibly valuable for all of us. In the sense that like the tale of the Ramayana is valuable in many ways for our day-to-day life. As is the story of Gilgamesh and all of the epics that have preceded us, right? So there is a baby in that bathwater, and I'd love to know what that story is. There is no specific reason why they should be hoarding it among themselves. No specific person owns it, so I'm not sure whose private property this is, or they have not created it. Whose rights I'm violating. And if on a trip to visiting them, I were to read this book, take out my phone, take a few photographs, and it showed up on LibGen or Anna's archive. Would that be fine? And if not, why not?
So I think, again, with a lot of these community efforts where people are trying to block off knowledge, right? So I think the example I mentioned was the Aotearoa community in New Zealand. I think that's the one that's very commonly spoken of. And they have basically said that we have created these data sets of people of the indigenous tribes. And we as members of the community are stewards of this knowledge. If you want this knowledge, it is not going to be open access. If you want this knowledge, you come to us, and then we will tell you whether, we want to engage with you or not. And you can make the case that, oh, well, of course, in a community, there'd be disagreements. There'd probably be someone in there who would want it who probably doesn't care. And it's like, oh, everyone in the world should know what my community is doing. And on the other hand, so basically there are like disagreements within the community. Some people would want it, some people would want to protect it, right? And correct, so I think the sense of your question is like, whose desire should be honored, because there are disagreements within the community. Right?
That's one question, but also why not be consistent and say they also get a 10-year license, just like the researcher who built a data set for something that's valuable. We're giving them a 10-year license and then saying then it's open. Why not treat it similarly?
Well, so in part because I think when you say why not say that, I think again there is a paternalism in that I get to decide. It's not like it's come from that group, right?
As in the state of New Zealand.
Sure, but like as a state of New Zealand, so the state of New Zealand is in part expressing the desires of the people who are in it, and is in part imposing its desires on the people who are in it, right?
Correct, yeah.
So I think when you're saying that the state of New Zealand should say like, oh, of course the state of New Zealand, but I think the conversation that we're having right now is like, should the state of New Zealand, like,
exactly, yes, yeah, that's it, yeah.
So what I'm saying is that I think at present the community will say that no, this regime of like a 10-year license, right? When you say that I as the state supersede the interests of this particular community, and therefore this 10-year license should, you are there, bound by the community at present will say no, I actually don't think, because I think this knowledge is something that if it is bound by a 10-year license, it becomes open, it will somewhere hamper our way of life, right? I have actually I have not answered your question, but let me step back and try and understand what you were asking. So you were saying that should this community be allowed to do this, right? To protect its way of, like, to say that this knowledge is cordoned off.
Should we have inconsistent norms?
Yes.
For other citizens in New Zealand?
Yes.
Who create books, write stuff, whatever.
Yeah.
And communities like this, which have collectively owned knowledge, that's historical, that's ancestral. Should there be different norms for these two sets?
Yes.
Yeah.
Yes.
And
again, I think the reason I'm saying that there should be different norms is because, when you say, like, say something like inconsistent, you're working with a certain definition of default, right? And I'm saying that default is not self-evident, right? And so therefore, if some group has historically not adhered to that, what is appearing as default to you, it is equally valid, right? So it has the right to coexist.
Yeah, that's true. But we do not extend this understanding for cannibalism, right?
Mm-hmm.
Like if they practice cannibalism, then we just say, no, we don't do this. Like you may so have practiced this in the past, but our modern sensibilities just say that we are consistent across the board. You can't go on eating people.
Sure. So I think, yes, like, again, there's always that tension between like federalism versus local governance, right? And so there are certain issues clearly on which, and I think if the question is, okay, but why specifically on these knowledge systems, right? I guess if I had to think of it like specifically, say the outer example in the context of data scraping, etc., is that is the exception now. Like, what is the marginal benefit that the state gets, or what is the marginal benefit that like an entity gets by having access to this, versus what is the marginal benefit that this community gets? And I think it's not that high for the state. It's probably very high for this community, right? So from that perspective, to me, it's hard to make that argument on just like economic grounds, because what's happening with data scraping is that at present you will guzzle any like iota of data that you find, right? Because it's such a cannibalistic drive for data right now, right? Like where it's like wherever you can find it, suck it up. Without any like understanding. So in some ways, every archive, every story, everything is the same when it comes to AI, right? Like there is no understanding of aesthetic, there's no understanding of texture, right? And so in that, so that is this is a way of operating. AIs have a way of operating where everything is just homogenized. And so for it, like one more scripture is just that. It is equally the same as like the next bit on the public web. That's not necessarily the case for this community, right? Where it does look at this data as something that's very rich, it's something that's very lived. So I think like the marginal benefit of keeping it for them is very high. And I think at this point, it doesn't make as much like sense for the state to say like, no, but your data should be like accessible to everybody, for scraping. I think what I'm saying is easier to argue for in the context of scraping. It's harder to argue for in the context of knowledge sharing, which is what your original question was.
Yeah, because I feel like even a drive for scraping ultimately comes from the drive to process and understand knowledge and to draw inferences and then to put that out into the world. It is a means to an end. Scraping is not an end in itself.
Sure, scraping is not an end to it itself, but I don't agree with your characterization of AI being a knowledge seeking.
Oh, I'm not speaking about AI in specific. Yeah, I'm just saying that the enterprise of scraping is traditionally embarked on the mission of producing knowledge. Like when you say that you are David up against a Goliath. What you're trying to do when you receive a cease and desist notice is effectively you're saying I'm just scraping what is publicly available to be able to draw inferences.
But see, I mean, I think the contrast would be, so there's the out era community, which is the indigenous tribe, and then you have, say, 4chan, right, which you could say is also like it is a pretty dense community, right? No one is making that argument for 4chan.
Dense is the right word.
Right? Like no one is going and saying like, oh, I mean, I wasn't saying dense in the sense of daft, but anyway.
No, I spent so many hours on 4chan. My God, that there are parts of of the 4chan boards that are dense.
But I was saying that no one's going to say that don't go scrape. I mean, I will not no one, but I will not go say don't go scrape 4chan boards, because there is like, again, like the cost of like not knowing what is happening in those communities is pretty high. Right. If there is violence that emerges from those groups, like you kind of have to know what's happening in those groups. If on the other hand, like, so if I had to think of, say, like the Amish community, which is also, fairly closed off, right, doesn't engage as much, and they have textures, and they're like, we don't want. It is so also again, like with say something like 4chan, there is this whole thing of anonymity, like where it is like you are writing content for consumption of random people on the internet, whereas that is not the case with Amish communities, that is not the case with indigenous tribes, right? So I think there is like, of course, like that distinction about like what is publicness comes back, and if let's say there was the potential of violence emerging from one of these communities, I would say yes, it is important to understand what is happening there, but not. I don't think that case has been made for any of these. So why are we going and trying to supersede?
But religious studies, right? I mean, I can think of like a Jordan Peterson writing the map of meaning or maps of meaning, whatever his first book was, and saying that I'm trying to build a map of meaning that comes from scriptures from across the entire world. So there are some stories and mythologies that seem to repeat themselves multiple times over. And if only I had more data sets. The Amish data set,
but I think then it's like, is your desire for knowledge, right, and therefore the social capital that emerges from it, does it supersede the desires of this community, right? And I would say no. Even if, right, I would say no, because so again, like I think so a lot of my arguments are contingent on like what reality is, right? And so I think it's possible for like good ideas to get out there, right? And if someone has to get credited for it, it can be that community, right? So I think, for example, the Out Era example, none of us knew of this group, but we all now know of this group because they have sort of very visibly asserted themselves as a group that is going to do something different from the others, right? And therefore now it's like, oh, like what is this knowledge that these folks are holding, right? Before that, I think we were not. I mean, there are so many tribal groups in India. It's not like we know or are worried about. And like at an event yesterday, for example, I was talking to folks from Project Vani, and their whole idea is to go and collect dialects and stories from every district in India. And that would cover a lot of these tribal groups that are not asserting themselves, right? So it's actually a very interesting contrast to what the Out Era group community is. I lost my chain of thought. So your question was, say your question again.
Okay, it's the same question, but I'll paraphrase a little bit. You're saying that your search for knowledge,
does not supersede if a group of people have decided to assert themselves and say that I do not want to share this information with you, your quench for knowledge does not supersede that.
But in the instance it is like an author or a filmmaker, then you're saying give them a license. 10 years later, then you can supersede. That is, I wanted to read this book, and this person, doesn't want me to read it. The publisher is going to read it, but
again, like the issue is about again publicness, right? Like when that author has written that book, that author has written that book for public consumption, but wants to be economically remunerated for it, right? But that is not what's happening with the community. The community doesn't want this information to be public. It does not want this information. They possibly want some economic compensation for it for like very restricted instances.
And just to double click on the claim that an author writes of public consumption, another way to phrase the same sentence would be the author writes only for the consumption of those people who pay the author to read the book, and not for public consumption.
So the author, yes. So the author writes for people who pay for the book. And I actually think you're making the flip argument for the group, right? Because what you're saying is that, no, I see where you're coming, right? Like you're saying that the author has written something which should expire in 10 years. Or I am saying that, like, if you've written something like as an idea, it should expire like in 10 years. Whereas you're saying that, well, why isn't that what you're also saying for the...
That's what, and so but you said that you can have an inconsistent. So you said, the state can actually impose inconsistent rules for different subsets of people, given the context. Like this is community-owned knowledge, that is not. There are some examples. So I'm just trying to get to the heart of how we decide that.
This will click. My fear is it'll click after the podcast. But
if it does, I promise I will leave it in the show notes so that.
No. But let me try and think about this right now. So why is it that we say that the rules of the community should not expire after 10 years? So I think, one, again, it does come down to this question of creation, right? Has the community created that knowledge as opposed to as something that has been held by it, right? So like there is this idea of like, say, custodianship, and again, because they're not thinking of property in the same way, therefore like this whole thing of like, I need incentives to produce that knowledge don't hold, right? So I think that is definitely one point of departure. Now, as custodians of something, right, where let's say there is a understanding of like whatever has been produced is larger than all of us, you're not looking for economic incentives. It's almost like your way of looking at this knowledge is like I owe something to this larger collective body. So then it just becomes a very different way of, I think I'm now speaking on behalf of, and I might be incorrectly speaking on behalf of all like the intentions of some of the people who are involved in some of this work, right? And therefore, like these alternate norms exist.
Yeah, this is like, in one way to say, practically in the domain of like private information. It's like giving out an address.
Is it? But I'm saying it's not just that, right? Because like when you give out like your address, it's still something you can say like, this is mine. Whereas I think with a lot of this indigenous texts, etc., right? Like where the question is, we don't know who produced it. It might have come from like 100 but there is this sense of like, this is larger than the self, right? And therefore like there's like a certain kind of reverence. There's a certain kind of like, and so I think then therefore the forms of governance of all of it are very different from how you look at individual authorship, individual books, etc.
Yeah, in the sense that, it is ours as opposed to it is mine, and it is ours in a way that is sacred.
Almost, yes. Yes. And I think like when this whole notion of property right is so tied to the individual, that if you had to like enforce on it, you would be imposing like a way of life, which this group does not agree with, specifically in context of some of this work.
Got it. I feel like one of the things that I've been sort of misleading this conversation into is like conversations around things that are not specifically public. Because one of your caveats you started off was, you said that in as much as this is public information.
Yeah.
And the example of the tribe is not public information, right? It clearly doesn't meet the definition of this being public.
Yeah.
But now just coming to the digital world.
Yeah.
If you think about a Substack that I write, but it is paywalled.
Yeah.
Right? It is subscriber access only.
Yeah.
Does that meet the definition of something that is publicly available and can be scraped?
Yeah. I do want to, before going into the paywall thing, I was thinking about the free Substacks, right?
Yeah, correct.
Which
we can do that way, yes.
Yeah. Do you know what the norms for Substack scraping are right now? Do you know if it's enforced, like what is Substack's own policy on scraping?
No, I don't know.
Yeah.
But again, like a good additional question would be, should it be respected?
I mean, no, I think robots.txt is...
And LLMs.txt, nothing.
I think they are more... because, again, like a Meta, a Twitter, all of them would also use it, right? And I think even if Reddit and Twitter are not providing APIs, I think people should still be on these platforms. And so in that NYU versus Facebook, right, there's been that case where Facebook went after NYU saying... collecting data was violating user privacy, which not to give Facebook the benefit of the doubt, I see the argument because they've been sued for violating user privacy when researchers use the data, right? So I see the argument. But I would say that no, in all of these cases, when all of these platforms that are designed for virality put a robots.txt, it should not be honored. Because I think that robots.txt is kind of meaningless, right? Like you can't have it both ways where you say that, oh, I want virality and I want like I will make money from the more public or a piece of content goes, but I will not share this data, or I will come after anyone who no, robots.txt is not saying that. It's basically saying like a very polite way of saying like, please don't, right? And obviously when it comes down to say individual websites where, you know, a small publisher, which would also be like say Tattle's website, right? If someone starts hitting our website and scraping, there's not that much content, but at all times there would be an economic cost to it, and it would be a nuisance. It would slow down our websites, all of that, right? I actually think this is a place where like the market needs to step in, because this is something that can be technologically solved, rather than something that needs to be legally. One, it's not enforceable. So like me having a robots.txt on my website is not legally enforceable. And so I would say that yes, like this is something that like, because it should just be technologically solved. So the in principle question still remains whether LLMs should be, or whether I, as like, let's say I was building a bot, would I go to an individual creator or like an individual small website and like scrape their content when they have said, I do not want this for LLM consumption.
Yeah. And then of course this will drive all the way back to the Substack question and the paid Substack question. Yeah. We're starting at the lowest hanging fruit.
Yeah. Yeah. I think morally, no. Like as my personal intuition would be like, no, I like to honor people's consent, right? But again, so much subjectivity in this, right? Like for example, if I know this is an individual person's this thing, I would say no. But if I saw that this was a 4chan-like platform, I would do it anyway, right? So I clearly have inconsistent principles, and I think therefore I have converged to the point of saying that I think the easier thing to do consistently is to be able to scrape everything that is on the internet, that is on the public web, and then for the people who don't want it, like have technical methods of preventing it. And I think separately I would rally folks who do publish on the internet to just become comfortable with eventually having a bot that like speaks in your voice, right? So I mean the Tyler Cohen argument is like we should all be writing for the bots of the future, like we should all be writing for the large language models. But I mean I'm not saying that. And I also am not actually that worried that there'll be a bot that, for example, will speak like me. I mean, speak like me only to the point that they would enable like scams and cybersecurity, yes, but not not worried in the sense that, oh, like my intellectual property, because I don't think ideas are that like statistically reproducible. I think like good ideas are not just a function of statistics. So I think that's strategically this is what I would do. I would say I would go to people and say like, please don't stop writing on the internet because you're worried about AI chatbots imitating your work. And separately, like maybe like get comfortable with people or with entities scraping your content. And then separately, like also invest in technical infrastructure to like block it off when you don't want, because it impedes your existence, right? Not because like of the future risks, but because it's coming in the way of your day-to-day operations. Yeah.
Got it. Okay.
And then I think had to go back to the Substack question.
No, but
right?
I'm also okay if you want to run into a quick break, get a little bit to eat, and then we can come back, because I feel like this specific question, the Substack question, is going to take like a good 15-20 minutes minimum.
Yes.
Okay. We will see listeners after the break. Hi, Tarunima. Welcome back.
Yes. Hi.
During the break, you looked up Substack's scraping policy. So for the listeners, what is it?
It says scraping is not allowed. It is illegal, and I guess in all threatening terms, will be penalized.
But this feels rational, right? To me, it feels completely logical. If I was running Substack, I want to defend to as much of an extent as possible the publishers on my platform. The default position is no, you can't scrape anything. And then by extension, let's see, like you can come to me. If you're a corporate, then we'll expose this data to you, whatever. But I'm presuming that we still can scrape because all this is public access.
So again, like I think the paywalled versus non-paywalled distinction matters here, right? So if it is non-paywalled, so like again, interestingly, right? So for example, Bloomberg Law, like you have a lot of these market analyst websites that have relied on scraping news websites for a long time, and a lot of these websites are paywalled.
Yeah.
And so, I think there is a good case to be made. Well,
it doesn't matter. So to be honest, I think that the existence of paywall is not a real thing. First of all, it's not a physical literal wall. Right? It doesn't. It's not. It's only like a piece of UI that prevents you from accessing this information.
Sure.
One way to think about it, like logically, would be let's say that you had to pay 100 rupees to access an article, and then we keep dropping that number, right, till we come to 1 rupee to access the article. You'd say that between 100 and 1 rupee, or even like 1 paise, the rules would be the same because they're all quote unquote paywall, irrespective of how much you have to pay to get across this UI wall. Okay.
Yeah.
But imagine there was a 0 rupee transaction to be made. Like it shows ₹0.
Yeah.
You have to enter banking information, click yes, right? No money is actually debited from your bank account, and then you access this article. That would also be paywalled, but you've not made a payment. At which point, that's the same as not paywalled. Like, I'm not able to see the clear distinction, actually.
No, I think you're right about this. Where my mind's going is like the analogy between Substack writing and a book writing, right? And so, for example, if I am putting one chapter out of my book every day as whether or not it's paywalled, but on Substack for my subscribers, that's one analogy. And then the other analogy is where I was saying that if something is being designed to be discovered, if it is being designed to be so on social media, etc., right? Like if you're putting something out saying, I want more and more people to read this, then why is it now not okay for a bot to read it and for it to ingest it, right? So I think don't have a good resolution for this. In that, like, should we say that there should be licensing for Substack content, and that eventually, if it is analogous to a book, and then that eventually 5-10 years later it'll become
it'll expire or whatever.
It'll expire, right? Like, should that be the position? I think, again, the more realistic or more tied to reality, I know what happens is that a lot of the people, entities, ill-intentioned, not ill-intentioned, would be doing this in any case discreetly, right? I think when you have any such restriction, and when, say, like, scraping becomes illegal, the use cases that it prevents are the ones who will publicly announce that they are doing something. And when you are, say, producing research or knowledge in the public interest, you have to publicly announce that this is where you've gotten your data from, right? That's the kind of use case it prevents the most. A lot of the clandestine scraping, etc., has continued to happen on Reddit and Twitter, will continue to happen, right? And so I think even with, say, something like Substack, I have no doubt that a lot of this scraping is anyways going to happen. And so to me, it feels like making this okay to say that we should all be allowed to scrape actually just makes it better for the smaller, more like loud and transparent entities to continue to do it, because I think the ones who are doing it for other reasons or are anyways doing it.
Are doing it anyway.
Yeah.
You use the word ingest for what a bot does, right? Like it ingests information.
Yeah.
And in that way, it is analogous to what you and I do. If I were to buy a subscription to your Substack and then read it, I've ingested the information. After which I'm able to go and have a conversation with my friend.
Yeah.
And clearly you're not precluding me from having a conversation about what you have written.
Yeah.
Because I'm able to use your knowledge, representative one-to-one, make an argument on behalf of your argument, whatever, right? All of that is allowed. If you think about what a learning model does, very rarely is it reproducing one-to-one the original work of the creator.
Okay.
It is ingesting information using a large data set and then turning that into, in exactly the way we do, something that is reproducible in the context of that conversation, the particular question being asked, right?
Okay.
So from that lens, is an LLM not bereft of all responsibility in exactly the same way we are not? In that this is not a violation of anything because we're not stealing the property itself. We're simply taking away the essence, the meaning, the idea, or the idea is hidden within the work, and then passing that along as part of a larger subset of ideas that we have access to, that we're exposed to.
So I think, like I said earlier, right, before the break, I actually think we should all just become comfortable with the idea that LLMs are going to do this, right? I think we all should just become comfortable and not be threatened by it. In no ways, I don't think LLMs are replacing humans. And I don't think just by looking at, say, if I ever wrote 6 books and like scraping 6 books, it has somehow become me. I actually would say that I'm aligned with you on this, which is that not because I think it's analogous to how humans engage, but more like you don't need to be threatened by it. Like let it be another another actor in this like network of conversations. It will not be the same as humans. We don't have to be afraid of it.
You and I can't be aligned because then listeners will start dropping off.
Okay.
So just to now the thing you mentioned about somebody sounding like you, right?
Yeah.
This goes into this world of likeness. Now, I remember when we were first going back and forth on what we should talk about. One of the things that I brought up as an idea was what we do with the likeness of other people on the internet, right? And because you're working on things like misinformation and deepfakes, for example, making deepfakes of other people, sexual or not, is fundamentally problematic. And so we were discussing whether to sort of address this as a topic, right? Isn't that one of the implications of being able to, for the lack of a better word, steal the likeness of somebody else? Simply because you have hours of me on this podcast, you can now reproduce any word in exactly the way I would say it. You can get me to say things, and then you can put that out into the world. That is fundamentally a problem still.
But I think it depends on whom we are speaking about, right? So, for example, when you are looking at someone who is a celebrity, who wants to be public, right? Who wants to be known, then and I think this is true even for AI generated content, that I think a lot of celebrities don't particularly care about it, right? Like for them, it's the same as previous forms of like posters, imitations, etc. Like for them, it sort of furthers whatever their intent of being on the internet is. I think it's more like when you're talking about, say, someone who is private, who is who doesn't want to be public on the internet, has shared content in confidence, or has shared content with certain assumptions of privacy, that like then it becomes an issue. Which is that it's not about like when you're saying like you've stolen. So I think like if you're doing 8 hours of podcast where you are saying that, or you've done all these episodes and you're like, I want as many people to hear it. If someone's making a deep fake of your voice, I think that's okay. But if someone is, someone who's a very private individual, has shared a photograph with, say, a family member or a friend, and that eventually makes it to the internet, then it's a very different set of concerns, right? Like they don't want to be public.
Do you think that Instagram is akin to a paywalled Substack? And the reason I ask is because specifically when it comes to deepfakes that are, for example, like AI generated nudes of people, right? This is primarily coming off of Instagram. So you've uploaded an image. You've walled entry to those who can come in and view these images. So it's a sealed off account. And you're putting up photographs that you want to share with this group of friends, family, whoever this subset is, who are able to, partake in what's happening in your life. That's an example of, I feel like a blurry line between clearly public and clearly not public.
So I think nudes is again a very different ballgame, because we're talking about a very different set of laws, right? Like when you're talking about non-consensual intimate imagery, it's not even about scraping anymore, right? But so I'm going to leave that aside, but let's just focus on Instagram, which is that it is a paywalled platform, which is thriving on virality, right? Like the entire business model of Instagram and Twitter is on content becoming visible to more and more people, therefore generating more clicks, therefore the platform making more money. Now, when that is the assumption, to say that, but it is public for all reasons, but for this one aspect, is inconsistent. Similarly, if say I want to be an influencer on Instagram and I have shared all this content, right? If people are going and scraping this content to make, to like more make, say I'm a photographer that does wildlife photography, and some, this PI bot does another wildlife photo or creates a synthetic media in my style of photography, right? It is like I understand, again, viscerally, I understand why it feels so wrong, right? But I actually think it is like if you want it for public consumption, you put it on Instagram and your profile is open, then it is game for being scraped.
Yeah,
right?
But on the closed profile front?
No.
Even if...
Because on the closed profile front, if I have said that I am using this, I do not want to engage in the game of virality. I do not want my content to be discovered, and I don't want my content to be discovered by a bot either.
Got it. What if it's one of the friends I've allowed into the walled garden?
Yeah.
Who is scraping?
Yeah. Again, scraping to what end, right? Like if let's say it's scraping and I like create a little montage and gift it back to my friend, like sure, right? If it's like I'm scraping and then breaching that boundary that I have determined, then no, right? I think where your question becomes more interesting is like what happens when it's photographs of both of us and one person is say like public and one person is not. Absolutely, right? That is where it becomes very interesting. And then it's like whose consent reigns, like the person who wants to be private or the person who wants to be public. I think as a person who wants to be private, I would just not be photographed with this person, and I would say like don't put me. And if this person in like direct conversations continues to supersede my desire, I would just stop getting photographed with this person, right? Consent is very murky, like especially online. But yeah, I think that's an interesting edge case. But if let's say I was using photographs of us together to generate a deepfake of people together, I would say that's more okay. But if like they're photographs of us together, but I specifically like clip out the other person and generate deepfakes of them, then that is not okay. That's not an acceptable use of scraping.
Got it.
Yeah.
So I'm thinking about the conclusion that you, first of all, I mean, I didn't think of the example. It's a brilliant example. I wish I had. So thank you. That's a great like counter way to push this. But if you're saying something like, since my voice is on the internet, and it's on Spotify, it's on Apple Podcasts, it's on all these platforms that are anyone can access, truly public access. Right? As long as you have an account with Spotify or Apple, you have access to it. And you've also concluded that we don't necessarily want to respect the terms and conditions embedded within the access control that the platform has laid out. So if Apple says you can't, use Deepak's voice, feel free to disregard that, because that's not a great, whether or not legally permissible, morally I feel like this is not really the way that we should be progressing with this subject. And the end conclusion from those two points of data is that then you can make hours of content that presumably Deepak is creating, made using Deepak's voice. Yeah. Right, we've like gotten this far. And I'm wondering, so for example, the Chat GPT voice was originally the same voice as the actress in the movie Her. Yeah. And this was quite an uproar at the time because she had, from what I understand, and I could be wrong, not consented to her voice being used as the voice that goes on millions and millions of devices and gets recognized as the voice that if I just say, hey GPT, what's the nearest, like cookie shop, that's the person who responds to me. And this person could very well argue that it's such a dilution of my voice. My voice will never again be heard the same to millions of people. The case for somebody who is a public personality being treated as special seems stronger than somebody who's a private. I understand the private player argument, but for public personalities, they tend to make all their money and their sense of identity lies in those things that are part of this expression.
So I actually think there's a distinction, right? There's a distinction in the case I was talking about and the case you're talking about, because the case I am talking about is us being concerned about our intellectual ideas, right? And so I was actually thinking more like the content. So like in the sense that if you are on Spotify and you want your ideas to be heard, and then you have a bot that basically rehashes your ideas and makes arguments on behalf of you, right? That is where what I was engaging with. I think the personality case, which I think Anil Kapoor also sued someone in like one of the AI companies in India, right? Is basically people saying that there is something inherent about my voice that is mine, that gets me sort of economic capital and should not be replicated, right? I don't know how long this sort of will last, because we don't have the same approach to mimicry artists, right? Actors are not going behind mimicry artists. They will go behind mimicry artists if mimicry artists are in films and then the film producer says, Anil Kapoor or Scarlett Johansson, right? Like that is when it becomes a problem. Or if you're not explicitly disclosing that this is not, because this is also what happened with, say, like the Manoj Tiwari deepfake, right? So this was a deepfake that went out in 2019 Delhi election, and this person was speaking first in Hindi, then in English, then in Bhojpuri, and only one of those videos is real, the other two are synthetic, and it looks very much like this person is speaking these languages. And why is that a concern, right? It's happened with the consent of this person. The only reason it's a concern is because it's conveying to the public an idea of, like, the authenticity in this case mattered, because it's conveying to the public an idea that I speak these three languages which you do not, and in a electorate like Delhi, it matters that you speak the languages that Delhi speaks. So similarly with the Scarlett Johansson case, etc., people might trust the product more, thinking that this voice is this actor or actress's voice, and therefore the actor or actress feels the need to step in and say, like, this is not my voice, you cannot use it, right? Because that voice itself implies certain things.
Got it, I understood. I'm thinking of an interesting example that came up in the world of AI.
Yeah.
So let's say I'm about to watch a movie.
Yeah.
Okay. Now, I can foresee a future, 15 years, 20 years from today, where we no longer need actors and actresses. Because you could render an entire movie from scratch, a fully coherent movie from a script, and pick lighting and sound direction, all of that just through some sort of like an interface like a computer, and have an end output that is going to be a movie. At which point I could churn out an infinite number of movies featuring, I don't know, like a Deepika Padukone, or any famous actor or actress, and because they're a public personality, and because we already have enough content of them on the internet, it's possible to train a model that accurately depicts them in sort of various positions, various lighting, right? And so to get the video right. Now here I'm trying to bring the idea of the license that you mentioned earlier, right? We're saying there is something here, something about the likeness of a person that is like their intellectual property. But I don't know if we can specifically grant a license on this. We can't say that it's not, you have a 10-year license on your likeness, after which people can start making movies that look like, which seem like you are in that movie, and put you in roles within the movie without your consent. That would be problematic. So how does this superimpose in a world of LLMs, where we can train models on infinite numbers of things? Is this sacred now? Is it sacred that no, you cannot reproduce the likeness of a person? And in your moral estimate, I'm not asking, because legally, of course, that's already the case. You can sue. But because you've already proposed lots of things that are not within the legal bounds, but what you believe to be correct.
So no, again, I think what I'm saying is that we should not take this position of, like, no one should be, you should not be able to reproduce likeness of me. I think Grimes famously has started licensing, right? So people are allowed to use, I think, her voice. And I think pay her some money, like some royalty for using the voice. So there is an argument, I think, in generally with technological determinism, where people say that, let's not assume that technology, the way technology is right now, is how it will always be. Regulation, social pressure, etc., changes the directions, right? I think with LLMs, it's really hard to go back to a point where there is no data. Like, we have seen what we have seen. I think there's going to be... I don't think the business case for LLMs is as strong as a lot of, like, evaluation, like, estimates are making it out to be. But I also don't think that we can go back to a point where, the data licensing becomes so extreme that we go back to a place of zero LLMs. I don't think that's going to happen. In part because Common Crawl is it's a repository that already exists. It's hard to, like, retrospectively go figure out licensing for all of that content and whether that data was relevant for AI. In part because Google has YouTube, that's a lot of content. It's still going to be able to train its models. I think Meta's trying, right? So I think we might find, like, more interesting models of data access beyond just scraping that will be legally less costly for companies, which is why they will go and do it. But I don't think we're getting to a world where there are no LLMs. So therefore, realistically, I think people should be willing to engage with their likeness emerging through AI. I still don't think it will make for great art. That doesn't mean that it won't make for some art. And whether that license for that content lasts for 10 years or, I don't know, 40 years, right? I think my sense is this is like something that the market will figure out, right? So it'll come down to individual contracts more than like maybe the state determining any one thing. So, for example, a more powerful celebrity might be able to come up with more like restrictive contracts and more, which I'm guessing probably happens with advertisements right now as well, right? Like people probably did.
Yeah, it does. The difference, of course, is that you are saying that there are cases to violate these contracts. In the example of the book publisher, even if an author were to sign with a publisher saying that I want a lifetime, it's just you and me and our readers, this book never gets out. You're saying that's fine, violate that contract, because I don't think that this way of contracting for public information is valid. So why should the contract be respected in the...
Again, so when we're talking about knowledge, right? Like I think when you're talking about books, and I'm saying that I think beyond 10 and 15 years, right? It is, it's okay if someone is going and actually reading this information, that the person has made the money they wanted to make. At this point, it's probably just helping distribution channels rather than the individual. I think with the artists, why it's not a function of like consuming information. It's a function of using that to generate generate a product, etc. Right? So I guess the interesting example would be like the M. Karunanidhi deepfakes that emerged in elections last year. Karunanidhi has passed away ages ago. We're obviously not asking consent from Karunanidhi saying like, can we produce deepfakes of yours, right? So similarly, I think for dead politicians, dead Bollywood actors or celebrities, I think that's going to happen. Now the question is, I think as long as a person is alive, to produce synthetic AI-generated content of them is, because it is again an authenticity question, right? Like by producing my likeness, you are able to leverage the trust that I have built to do something, and it has implications on my life, because if I'm advertising something wrong, so then it comes down to individual harm, and therefore I think those contracts have to be negotiated. So it's a very different ball game from say text, right? And it's a very different ball game from
I can
books.
see that distinction actually. And you feel like alive versus dead is also a meaningful distinction, that a person alive, but a dead person can't speak anyway, so okay. And then noting the paucity of time, I wanted to pick your brain finally on the subject of consent.
Yes.
Okay, this is, I think, a hard one, especially in these sorts of domains. So I'm going to hand the ball over to you.
Yes.
What does it mean to consent to something? What the hell is consent?
So I'll make this concrete again in terms of our work, right? So when we look at WhatsApp groups and we have to decide, is this group public enough for it to be for it to be scraped? And then the question that we have to ask is, because you have to assume publicness. Now, WhatsApp says it's an encrypted private platform, but you have group sizes of like, I think 10...
Correct. Yeah.
52, right? Something 1024. Yeah. That's the group size. And there is no intimate conversation that happens in a group size of 1,000 people. And we know that WhatsApp gets used for campaigning. So when you look at groups being advertised on Twitter, and for example, during the pandemic, we had a lot of these groups being advertised for Twitter. We assume that if there's a group that's saying that this is a WhatsApp group where you can find resources during emergency, for medical emergency, it's a public group. That's an assumption. And then there is this question of, like you might get consent from the admin, but you haven't gotten consent from like all the other people who are in that group, right? So again, this is a question that I think research ethics you have to deal with a lot. When you're on Twitter, actually, when you ask people whether they are okay with their data being collected, like a lot of people will say no, right? But like when they're reading research reports or like media articles, they don't realize that they're like, oh, it's how is this data coming out? How is this research coming out? It's coming out from like what's been collected from you. So I think consent, in some ways, there is like with all things tech, there needs to be like this upskilling or up-leveling of like the public conversation as well, right? I think there's definitely something we need to just maybe everyone needs to sort of get more on board with how some of these digital infrastructures work. I think as when you look at research ethics and when you look at, like, say, institutional review boards, when academia is talking about, when you do a study, you have to go and get an approval from an institutional review board, which will look at your study methods and say, is this ethical, is this not, is this responsible, is this not?
Right.
And the standards vary across Europe and US for sure. I think India doesn't always do a strict IRB. And I think it often does come down to this question of, what is meaningful consent, right? And I think that intuition varies. What you often weigh the meaningful consent against is how much data you collect, right? So when consent is not clear, the responsible thing is to collect lesser data, right? So you collect as much data as is necessary for research, and you don't collect, for example, phone numbers. You try and basically adhere to the principle of data minimalism.
Mm-hmm.
But yeah, because you don't have the consent to, and you're kind of making a lot of assumptions on the basis of the people who are there. So yeah, I haven't answered your question other than to say that I think consent is very dicey. But again, so much of research ethics is about, like, the reality of that work, and that you balance some of the constraints around assumed consent with how much data you're collecting, how long you're storing it for. That's my dissatisfactory answer, but you should probe at this.
Yeah. Because I'm also wondering, there are instances where you get to just say that your consent on the subject no longer matters, despite it involving you.
Yeah.
If you go walking on the street, which every time I go to Church Street, I hate the fact that somebody somewhere is going to photograph me.
Yeah.
Right? Because there is so many people with cameras out taking photographs.
Yeah.
But it seems like the social contract I'm signing. If I have to be on Church Street, I just have to run the risk of being part of somebody else's photo.
Yeah.
My likeness is going to be part of their image, which will be stored in their phone and presumably on the internet forever. Yeah. And that I have to make my peace with this fact.
Yeah.
Me walking up to them and saying, hey, I do not consent to you putting this on the internet or having it on your phone, does not in any way force them to delete the image or not put it on the internet. It's not their image.
Yeah.
So there are already instances where we seem to say, even if you so feel otherwise, we are not going to respect your consent in this specific domain. And then in some cases where it's paramount, where unless you explicitly consent, we are not going to proceed on this.
Yeah.
Again, speaking strictly in the realm of information and digital rights and all of that. It's not very clear to me how we draw the spectrum from really soft to really hard on the subject.
Yeah.
Outside of pragmatism. But in some cases, it is actually pragmatically possible to seek consent. And so we do. And an example would be that when you sign up to a website, you can explicitly have someone tick a tick box. Now, some may argue that even that is not meaningful consent or informed consent, because
there's a lot of work to say that's not meaningful consent, right? Because you're not reading terms of services that are drafted by a platform in its legal interest, right? Like it's as a
Sorry, but to add as a caveat there, you are choosing not to read. You still have the option to read.
Sure.
Yeah.
But again, like, the behavioral psychology research will say that it's not okay to, like, in theory you can read. The cognitive load is just too much to reasonably expect any human to read it, right? Or like to expect every human to, which is why you have, say, like, nutrition labels, etc. Like, in theory I can go and figure out what's in every piece of food item I eat, but like in practice I can't do that.
Yeah. Correct. Yeah, you are right, of course. That it's a hard read, and I feel like this behavioral point that you're making extends to even the product itself. When you're on Instagram, it's Nitin Pai argued on episode 2 that a lot of your engagement with social media is not consensual. When you choose to scroll left or right or go back, the algorithm is effectively tricking you. Or when you see a notification on your phone, you have been tricked into opening up that notification. If you hire a team of psychologists who sit in-house in your social media company, whose job it is to make sure that the recipient is scrolling non-stop for 45 minutes a day, it's almost impossible to beat human psychology at this scale. Like the colors are just perfect to be able to engage you. Just when you're about to click out, you'll have a notification saying, hey, new posts right on top, right? And so it's a collection of trickery to help you to keep you on the platform. At this point, it's no longer consent. Sure, but then what the hell is consent? Or we should try and define it in reverse. What are those conditions under which we think that truly and meaningfully this person has consented?
I think there are some cases where consent is quite clear, right? So, for example, if I'm sharing an intimate photograph with a partner, that violation of consent is a 100% violation of consent, right? So I'm actually going from the opposite direction, right? So
when you say violation, in what way? If the partner were to violate your consent?
Yes, if the partner was to like then leak the image, that's a complete clear violation of consent, right?
But where are the terms embedded?
So in this case, yes, it's not legally embedded. It is socially embedded, right? In that, I think there are enough things assumed about intimacy, right?
Yeah.
The reason, by definition, it is intimate. It is something that's an act of trust. And so when it is leaked, it is obviously I mean, I feel like that's splitting hairs. We don't even need to get into that conversation, right? What is interesting about, say, nudge, that entire theory is that, I'm forgetting what was it, paternalistic rationality, something of that sort, right? Like the idea being that, you're saying that there is free will, but you can like nudge free will. And then I think then the question is like how far, right? And then at what point is it no longer free will, which is, I think, what I'm gathering from the paraphrasing that you're doing of Nitin's argument.
I mean, as somebody who privately believes that we do not have free will.
Yes.
Yeah. I mean, this can go all the way. It can go all the way to that we consent to nothing at all.
Yeah.
Because we're just a consequence of the things that happen to us.
Yeah. Yeah. And I think we will do
sure.
trolley problems later. So there is, in research ethics, there's obviously meaningful consent, right? When you, for example, on WhatsApp groups, when you DM someone and you say that, hey, we want to talk to you about what your experience has been in this group. This is not something we've done. This is something that ethnographers have done. That's obviously very clear consent, right? Like, so there is that. I think when I was saying that, I think there needs to be like some up-leveling on like what is happening on digital infrastructures, right? It is to make the connections that people are not being able to make in terms of, this is what I'm doing in my little world, and this is what like the broader implication is. And that's not I don't know if that's a consent argument, right? In that we don't know what the answer will be. If people didn't have full knowledge of what their behavior leads to at like a macro scale, right? Like,
this is the informed consent bit, right?
Yeah. I think that is what the critique of consent on social media is, that we don't, or on the internet is, that we don't know whether, like, it's not informed consent. People don't know what they're consenting to, and people don't quite understand the consequences of what they're doing. I'm not answering your question, but
no,
but I think
you
we're
are
just
right.
like
I'm wondering what we do about
ideas.
this situation, because sure, I mean, I would like to claim that it is almost impossible to know what we are consenting to in most circumstances.
Yeah.
Even in sharing an intimate image across with a partner.
Yeah.
We approximately know what we are consenting to.
Yeah.
But there's no way to know. I mean, there is the statistical probability that our phones are going to be hacked exists.
Yeah.
Right. The statistical probability that, I don't know, like my partner loses their phone, and then ends up in somebody else's hands exists.
Yeah.
There are many things that exist that you cannot plan for, that you cannot sort of hold in contingency.
Yeah.
And so the consent is contextual. Like, you're sort of saying that, given all the things I know and what you know, by and large, I'm sort of saying okay to this. And the same is true for social media. When I first signed into Facebook, I'm saying, given contextually what I know, that okay, cool, like it's like a place where I can put up photographs, text my friends, I have to watch ads in return for this.
Yeah.
If the ads are catered to me, then it's obviously because you know what I'm interested in, so you're by and large collecting information.
Yeah.
There seems to be an approximate sense that most people have, and especially after the Cambridge Analytica hue and cry and all of the noise that's been made about what social media does with data. I don't think most people on Twitter or India's intellectual class are unaware of what data is being collected on Twitter, on Facebook, on Instagram. They still choose to be on these platforms.
Okay. Yeah.
And so it could also be that, I mean, one, I'm pushing back on do we really need to up-level? Like, I think most people by and large know what they're consenting to. 100% is never possible.
Okay.
But they have an approximate nebulous sense.
Yeah.
And then two, I don't feel like a true understanding of everything that goes into this would change so much the outcome of the choices people make.
Yeah. So let's start at what you said at the beginning, right? You were saying that my consent is contextual based on my understanding of certain like reality, like certain parameters, and those parameters might not hold, right? But I think in the example you were giving, consent has been violated in that very specific.
Oh, right, the intimate image one. Yeah.
That, I mean, I think there's no doubt about that instance where it's very clear that consent has been violated there, because it's not as if materially something has changed. It is more that, I have shared it under certain assumptions, and we agreed on those assumptions at some point, and then there has been a third party that has superseded those assumptions, right? Like, it has basically intervened. So let's not get into that argument. That's not, I think, the most productive bit to engage with right now, right? Now, what is interesting with, say, what's happening on social media is that when we were posting content in early 2000s, or any of us, right, what is very disappointing about the story of the internet is that something that was so promising, all of us were posting content online, writing blogs online, all of it, right? Everything that you ever thought you were doing for democratization of knowledge has eventually basically become fuel for certain entities to become a lot more powerful, right? Like, it feels like the worst form of subversion of a utopia, right? That's what feels very disappointing about the dream of the internet. And while I agree with that frustration, I don't think it was predictable, right? I don't think it was predictable in the sense that when people were posting on the internet in the 1990s, like, you knew what was going to happen in 2025, right? You did not know that we would eventually get to these large language models. And so that is a place where I think the assumptions have changed, right? Like, what was possible has changed. And so is consent therefore retroactive, right? Like, so should the writers of 1990, like the 1990s internet, or when you're saying the public up-leveling does not matter, I think it matters to the point that in early 2000s, or when the platforms first came about, this idea of clickbait was not, or you could, do SEO type stuff to nudge behavior was not known. But now it is known, and therefore, I will change my behavior on the internet based on what I now know is possible. And there will be that period of lag between, me doing certain actions, it enabling certain outcomes that I did not predict. There will be that overlap where, therefore, that activity data will continue or would still be a part of those outcomes. But that does not mean that you don't up-level or increase public awareness so that people change their behavior. Because I think what you can do is try and minimize that lag, right? You can try and minimize,
Yeah, I hear you. This is a logical train, I think. And to tie it back to just the research work, right? Now, as researchers, as data scrapers, irrespective of what the potential outcome of the process is, whether you are a small company trying to figure out something from a large data set, or you are building an LLM with billions of dollars in the bank, what is the line that indicates that we are going too far? So what is the line beyond which this is red zone, this is clearly a violation of consent? Because I don't think, so in this spectrum, I don't think a Facebook building an LLM is going to care too much about soft consent, hard consent. None of that matters, right? If by and large it is, I can access that information, then I will. Because it makes my LLM more competitive. If I don't do it, my competing business is going to do it. But what is the red line? Where do you say that not me, not Facebook, no one should be willing to go there?
Yeah. No, I mean, but we do have those red lines already, right? So Google will not train LLMs on enterprise accounts, information that's shared on enterprise accounts, right? So, I mean, some of those red lines are there already.
Would you as a researcher say, I will not train information on enterprise data?
Of course. I mean, I think there's so many red lines that we have already drawn in our work, right? So, for example, while we do have, we can write scrapers and collect information on every WhatsApp group that is published on the internet, we don't do that because we are consistently saying okay, can this group be assumed to be public just because it has been indexed on Google, right? And the answer is no. You don't just assume that to be public. And so I think the red lines are, and I say all of this with this massive caveat that only researchers are I think only publicly oriented who need to speak to the public, those researchers are the ones who are honoring the red lines, right? I know that we will care about this stuff, but I also know that when all of these groups exist online, there are a bunch of entities that are on it that are there for all sorts of reasons and will be collecting data. And I would even to them say please don't do it, but it doesn't matter. So I think like if I had to define what our red lines are, I think it is very much like collect data or from groups that are meant, or collect information that is publicly oriented, right? It is meant for public consumption, and therefore you need to understand what the consequences and what is being said in that public consumption, like in that sphere, right? Now that is my, in theory, red line. And I think what happens is that you have to define it case by case in practice, right? So like for WhatsApp that looks different, for a Twitter that looks different, for an Instagram that looks different. Like we are not going to make fake requests with and try and be friends with a private person just to be able to collect data from that. That is absolutely a no-go.
Yeah. As a final question on this arc, if there existed a competing tattle, somebody who was trying to do exactly what you were doing, but did not respect these red lines, they're not legally required to, by and large, and chose ethically not to, would they produce better research?
Would they produce better research? So I think, again, research ethics has already answered this question, right? Where we are saying that they probably will produce more knowledge, but at what cost? And we often say that cost is not justified, right? We do a very, very small bit of what marketing analysts or a market analysis company does, right? Like we know of so many entities that do have access to, and who will scrape, etc. But they don't need to talk about it publicly, right? And they do it anyway. I think because we are saying that this is public interest, right? We talk about it publicly, and I think a lot of the market analysis firms will have data and like will produce insights, that will surpass anything that we have. But none of that will make it to the public. It will make it to consulting reports. It will make it to like business decisions. So I think the short answer is yes. The answer, absolutely.
I want to, so at this point, I'm going to try and wrap up the podcast. Yes. But just before we do, the next time you come on, I would love to actually do trolley problems. So
with a lot more time. Yes, I will think about it.
And so as a final concluding question, in the original trolley problem question, would you pull the lever? Why
is this coming in a conversation on scraping? My answer is yes, but we'll have to get into it. Right?
That's fantastic. Exactly. We can leave listeners on a cliffhanger. You said yes.
Okay.
So I have to take the position no, which is the easier position, I think. And so that's for next time. But I appreciate you coming on so much. We've been going back and forth for months.
Yes.
So thank you for making the time.
Thank you. Yeah. I hope it was worth it. Yeah. It was definitely worth it for me to like think through my positions on some of this.
Likewise. I learned a lot about the space in trying to prep for this. And the format of having to go up against what you are saying just sort of helps push the discussion forward.
I'm sure I'm like such a frustrating person to like talk to, right?
I thoroughly enjoyed myself. I'm sure listeners enjoyed.
Yes.
You all can write into her, to me, if you all enjoyed the podcast. Tarunima, thank you for coming on.
Thank you.